How did this morning's argument go?
Well, I was there. Sorry I'm late. I guess that's a pretty good excuse for this panel that I was coming back from the court. The jurisdictional arguments made my head hurt. I mean, yesterday was pretty understandable, bad enough, but pretty understandable, at least for someone with legal training. Today, we have these very interesting, fascinating issues of what the U.S. government is doing there, first of all, because curiously, the Supreme Court took this case at the behest of the U.S. government, which of course agrees with the courts below. So it's effectively appealing a decision it agrees with and is enforcing DOMA while not defending it in court. So is that proper? Paul Clement was there to argue representing the House of Representatives, the awkwardly named Bipartisan Legal Advisory Group, BLAG, which takes 3-2 votes, 3 Republicans, 2 Democrats on every action that BLAG takes in the courts. And so does the House of Representatives have standing to defend the law, given that the U.S. government is not? I mean, there's a lot of discussion. INS v. Chadha seems to be the thing that's most concerning everybody about it, so everyone go home and reread that. But assuming they get past the jurisdictional arguments, it seemed like DOMA Section 3 is not long for this world. The 4 so-called liberal justices would probably strike it down on equal protection grounds. A lot of discussion about the inappropriate motivation of Congress in passing the law by Justice Kagan and Sotomayor, for example. Justice Kennedy spent all of his time musing both jurisdictionally and substantively on what he's going to do, but if I had to place a bet, and this prediction is worth what you're paying for it, that he would vote to strike down DOMA Section 3 on federalism grounds. So in effect, we would have a 4-1-4 decision. DOMA Section 3 is gone, but no controlling opinion.
Any more ideas? Evan?
So let me start by saying, in addition to thank you to the Cato Institute, that we all always say in front of every big argument, you can't judge from the argument, and you shouldn't really read the questions and the back and forth, which were fast and furious both days here, and particularly complex and contradictory. So that's what we all say, and then everybody immediately starts to tell you what they think is going to happen. And I really want to underscore that from both days, the mix of questions and issues and constellations of justices and crankiness on the part of some justices, which you can attribute to either sort of feeling compelled to do something they're not quite comfortable doing, or not wanting to do something but feeling like they should, and that's also sort of a guess, really makes it very hard to say on the basis of these two arguments exactly what's going to happen. And I think you really need to take every prediction you hear and read and see tweeted and retweeted very, very skeptically. The justices are going to go back and delve through a mountain of briefs in both cases, a huge amount of evidence and argument. They're going to, as you all know, be circulating opinions, and that's going to lead to challenges that some may have that they think they're going to try to write it in a limited way this way or in a direction that way, and realize that it may just not write the way they're trying to write it, let alone how the 5 may or may not come together. So I think there's really an important reason for caution in all the predictions, including mine, that you're going to hear. Having said that, let me say there are 2 things we do know very, very clearly, and then I'll talk very quickly about the arguments. One thing we know is that while the justices are doing their homework and going through the process I just described, the best single way we can maximize winning the freedom to marry and even getting the justices encouraged to do the right thing as they deliberate now in the court is to do what we've been doing, which is to continue winning more states and to continue winning over more hearts and minds. There are as many as 4 states that are going to be considering, that have already begun considering freedom to marry legislation and could pass those bills into law before the court hands down its rulings, likely at the end of June. So the single biggest thing we can do to maximize the chances of winning are to pass those marriage bills and to continue growing the extraordinary who's who of America that have stepped up over the last many weeks and months supporting the freedom to marry, including in just extraordinary amicus briefs in front of the court briefs in front of the court, but also in the public discourse. All of that is what creates the climate and the momentum that encourages and emboldens and helps justices to find the right constitutional and legal roadmap. The other thing we know is that clearly the freedom to marry has the momentum and has the winning strategy. The strategy that has brought us to this moment of hope is the strategy that will bring us the freedom to marry nationwide, whether in June or in the round of work leading to going back before the court as soon as possible. One of the questions and exchanges that came up in the court yesterday was to point out that the Supreme Court got interracial marriage wrong before it got it right. And it was actually only a few years before the best named case ever, Loving versus Virginia, in which the court struck down race restrictions on marriage, that the court got it wrong. So whatever the court does in June, we have the freedom to marry winning strategy if we keep doing the work. That said, I'll just very, very quickly say, I think yesterday all the commentators would agree was complex, choppy, lively, engaged, hard to exactly peg and predict, and the gestalt of, I think, the immediate reaction today was very much what, well, I'll say was sort of what Ilya said. I'm going to disagree a little bit for whatever this prediction is worth. I actually think it was clear that the chances of the court striking down the Defense of Marriage Act are far greater than not striking it down, and I actually think equal protection as well as federalism concerns is very much in play. And what was particularly striking yesterday and today, and I'll stop end with this, is that no one in court offered a reason to justify the denial of the freedom to marry or the Defense of Marriage Act. What the opponents were pushing was, don't go fast, don't do it now, take your time, let's have a pause button. Absent was any good argument for continuing this cruel and harsh discrimination against gay couples.
Well, the big one thing that Clement kept talking about was uniformity. That was he never mentioned anything beyond that because, of course, the federal interest is going to be different than the state interest. Yesterday was all about child rearing and social, moral development, police powers of the states, etc. This is different. And so what is the federal government's interest? And so Clement kept pounding the uniformity, and there was obviously a lot of pushback on that.
Yeah, but the reason I say it the way I say it is you're correct. He kept saying uniformity, was unable to tether it to any actual policy, let alone legal or constitutional specificity about gay people.
Ken, did you have something? Otherwise, I'll jump in.
I just would make 2 points, and I won't reiterate what you've heard, but I think Evan made 2 points that I think are really interesting from my perspective. First is I do think Evan's point about why we are where we are today, I think is worth noting. What is, in my judgment, so galvanized the public is our stories. The story of Edie Windsor is an unbelievably compelling and unfair story. The fact that someone who did what we all think is the right thing to do, which is found a partner, spent her life with the partner, and at the end of a long life of commitment and of love and of support, is faced with hundreds of thousands of dollars in taxes. And then you look at Chris and Sandy, and you look at the plaintiffs in the Afer case, in the Prop 8 case, in the Perry case. And again, you've got folks who are trying to do the right thing, and they're punished for it. And so I think those stories, those examples, these aren't concepts, these are real stories about real people, make a gigantic difference, and I think that made a huge difference. Second, I think, is look at the panoply of amici in these cases. It's not just that there was a large number, it's the cross-section of society. It's military leaders, it's religious leaders, it's business leaders, it's Republicans and conservatives, it's leaders of excellent think tanks, all making the case from their perspective and why it makes sense. Big change doesn't happen in a single direction. It doesn't happen from a linear perspective. It happens when suddenly, all across society, people speak out from their perspective and explain why. That's point 2 that I thought was really interesting. And then point 3, to Evan's point, what's interesting to me is often political debates come down to a debate between what I would describe as substance and process. And this is not to denigrate very important substantive questions are being raised by opponents of marriage equality, and they ought to be discussed, and they're important issues that we ought to take very seriously and we ought to respect and respond to and listen to. That having been said, if you listen not only to the lawyers in court, but the advocates speaking publicly on television and other places, what's interesting to me is, whereas maybe 5 or 8 or 9 years ago, a lot of what I would describe as substantive arguments were on one side, today they're overwhelmingly on behalf of marriage equality. Whether it's about fairness, whether it's about what's better for kids, whether it's about freedom. And when one side says fairness, freedom, better for kids, and opponents say process, usually the former is a lot more compelling to both judges and to the public than the latter is. So those just slight additions to what have been excellent comments already.